Well, good morning, everybody, and welcome along to our next edition of our business law series. And today is all about fair pay agreements. And I am joined today by Andrew Shaw, a partner with the law firm Lane Neve, and Andrew's based in Christchurch. Andrew, welcome along.
Thank you, Stephen.
And without stealing any of Andrew's thunder, fair pay agreements, one of the biggest upheavals in employment law for a decade, if not longer. So it's certainly going to be something worth knowing about. So just before I hand over to Andrew, I just want to share with you our disclosure or disclaimer for today. And very important, so a couple of things. We're not providing any financial advice today. We're not providing, we're not here to sell any financial products or advice, as is the case with these matters. Every business situation is going to be different. So the key point of this statement is to make sure that if you become part of a fair pay agreement or are undertaking anything with respect to this legislation, that you do take your own professional advice as is appropriate to your situation. With that out of the way, I'm now going to hand over to Andrew. We will have time for questions, so please fire them through in the chat as we go, and we'll deal with those. So Andrew, welcome, and over to you.
Great, thank you. Fair pay agreements have been on the government's agenda for a very long time. They're finally here. And today we're going to look at what this means for your business. So the agenda is such. So we're going to talk about what are they and who will they impact. I'll then have a little look at the process. We'll then look at the content of fair pay agreements, both the mandatory and the required to discuss, some positives and some challenges, and what we are yet to know. So Fair Pay Agreements Act 2022. It's interesting because the Act actually hasn't been formally put up yet. What we see is a Fair Pay Bill. So if you see the Fair Pay Agreements Bill, don't worry, the Act has passed and it will be coming into play. So if we start with what this is all about, Honourable Michael Woods, when he talks about the Fair Pay Agreement, said its primary objective is to improve labour market outcomes in New Zealand. And really they're saying we do this by establishing minimum employment terms for either an occupation or industry. And what Michael Woods said when bringing this Act into play was that if you look at Australia, the wage rates over there are higher and the productivity is better than New Zealand. And he says that that is because there is sector bargaining in Australia, similar to the Fair Pay Agreement. Whether that would occur in New Zealand, we're yet to see, but certainly that is the primary objective and why we're looking to do this. So let's look at what this Act does. It's either industry or sector-wide agreements. So at the moment, you may have an individual employment agreement or a collective employment agreement in your business. Individual employment agreements between the employer and the employee. The collective employment agreement is between the employer and a union. And the union's members who are covered by that collective are bound by the collective. Now, you can have MECAs as well, which is a multi-employer collective agreement, or a MACA, a multi-union employer agreement. What this is going to do is to have a whole industry-wide fair pay agreement throughout New Zealand, or a sector-wide fair pay agreement throughout New Zealand. And it will provide for minimum terms only in certain areas, and we'll talk about that soon. But what they're really aiming here is for a more even platform for collective bargaining. In New Zealand at the moment, union membership is still relatively low, around the 16–17%. They believe, indirectly at least, that by having fair pay agreements, more people, whether they're union members or not, will be covered by union bargaining for them. So it came into force on the 1st of December last year. And again, we're yet to see the Act, but the bill is in play. There have been 4 registered fair pay agreements, 1 in hospitality, 2 in bus drivers, and 1 in supermarkets. Now, as of yesterday, 1 of the bus drivers has withdrawn. so that there are 3 in effect which are going to proceed. Hospitality was the first to notify, then bus drivers and supermarkets. We think bus drivers might be first cab off the rank. The reason for that is that they have an employer bargaining side, they have the union, and the jobs relatively are sort of similar in terms of bus drivers and perhaps cleaners. So as Stephen said, this is a massive change in employment law, and given everything going on in New Zealand at the moment, you would think that this is perhaps not so important. But really, since 1991, this is the biggest change we've seen in employment law. So really, it is a long time in the making. And also the government in part blames the 91 employment legislation for why productivity perhaps in New Zealand is so low. If a national-led or right-leaning government was to be elected in October, we suspect they're likely to repeal this act. Now, that's not guaranteed, of course. So what I want to look at now is the proposal, and I've picked up here MBIE dashboard, and what you will find is that MBIE is very heavily involved with this process of fair pay agreements to a level where they're really going to have to get further resources if there's a lot of fair pay agreements brought about. The government thinks about 4 or 5 of these will be dealt with each year. And at the moment, as I say, we've got 3. I'm personally aware of another one that is ready to go, and we'll wait to see if they lodge soon. So you can see there the dashboard of how it proceeds. So applications are firstly assessed, and at the moment we have the 3 which are assessed. There's then a 30-day or 30 working day time frame for public submissions. I'm not aware of significant public submissions on the 3 already in play. A decision is then made by MBIE and matters proceed. The bargaining sides are formed, and if the application is approved, the bargaining sides are formed, that takes up to 3 months. So on the one side, the bargaining for employees as a whole will be the union. The default there will be New Zealand's CTU. On the other side will be the employer bargaining entity, and we'll come to that soon. And if there's a failure there, we can't get one, we'll go to Business New Zealand. If they don't want to be involved, it will go to the authority. So bargaining will commence after 3 months, and this is very similar to bargaining with collective employment agreements. There'll then be a compliance and coverage overlap check, and that compliance is, are you complying with the Fair Agreements Act, as it will be hopefully soon, and secondly, whether there is another fair pay agreement which overlaps, and if there is, you look to take the better conditions from the 2 overlapping fair pay agreements. Then there's a ratification and verification process, which goes to MBIE's CEO. Bargaining will cease. The parties will confirm that with MBIE. Then there'll be an enforced FPA. So what will happen is MBIE's CEO will issue a notice, and there has to be secondary legislation to bring that fair pay agreement into play. And then if the applications are declined, then MBIE will be confirmed. So what you can see from this is quite a complex process, which is very new to New Zealand. It will take a long time. We're yet to see whether the first fair pay agreement will actually be passed into secondary legislation before the October election. And again, if the election goes to the right rather than the left, what will happen after that, if in fact a fair pay agreement is put in place? So how are they initiated? The first way to do it is 1,000 workers in an industry. So if you have more than 10,000 workers in a certain industry, you'd probably want to go to the second category, which is, you want to stick with this, 1,000 workers in the industry. If you have more than 10,000 in the industry, you might want to ensure that you look to get 1,000 workers throughout New Zealand. The second way is 10% of the workforce. And so again, if you have under 10,000 employees, this is a good way to go. And we've seen both these categories looked at the moment by people trying to initiate fair pay agreements. If, however, the authority believes that there are vulnerable employees, for example, low paid, working unsociable hours and a lack of collective unionism helping them, they may look to initiate a fair pay agreement on that basis. And when we look at categories of employees, you'll go to look at the standards which are out there in terms of Australia, New Zealand standards for classification of industries and jobs within industries. So who does the bargaining for the employers? So first up, the employer bargaining side is represented by employer association. So if you look at your own business, you then go to the association that represents your business. Now, most employer associations will not have experience with this other than perhaps elements of collective bargaining for a CEA. This will be new. The government will provide a $50,000 entitlement to a bargaining side, so that will assist them getting some expertise and to help them. Now, the employer association must be an incorporated society. So it's not the employer, but the association must be an incorporated society. And it must have at least one member that is a covered employer. And you would hope with an employer association that covers various industries that they would have at least one, if not many more. And there must be a purpose from that association of promoting collective interests of employers. So some associations may need to incorporate. Some associations may need to change their constitution, but I suspect having one member won't be difficult. The backstop will be if no employer association volunteers, and I suspect that could happen in some industries. Then after 3 months, Business New Zealand has 1 month to decide if they will become involved. When the legislation first came out in terms of select committee involvement, Business New Zealand weren't interested in being involved, and they made it very clear. The legislation's been changed so that it's voluntary for Business New Zealand to be involved, and they will if they decide it's appropriate. If not, then the authority will become involved if Business New Zealand and an employer association are not interested. So it will become the default bargaining party. One of the issues there, of course, is that's not really the authority's prime role at the moment, and they have a number of constraints on their time. So how will they be negotiated? Firstly, the parties must negotiate and attempt to come to an agreement. And what we talk about there is it must be applied in good faith. This is very similar to a collective employment agreement where even if you don't like the idea, you still must negotiate in good faith for a collective employment agreement. And you must agree to enter one, if there is good reason. In terms of good faith, you must be very much responsive and communicative in the process, which means if you receive correspondence from the union, you have to react quickly. You also have to go out to your employees and advise them of all the relevant matters. Once the terms are agreed, it will then go to a vote. So assuming that you go through bargaining and you agree on terms, so the employer and the employee bargaining parties, it goes to a vote. And it must be both employers and the workers. So if more than half the workers involved wish to vote and they vote in favour, that's one half done. If more than half the employers vote in favour, then again, that's the other half done. Now, noting that big employers will have more votes than smaller employers, and this is based on employers with 21 or less employees. And so over 21 employees, you get a larger number of votes. Under 21 employees, you get a proportionate vote. So you can see here that the bigger players in any industry will perhaps dominate the voting process, as they will, I suspect, the bargaining process. So if you can't reach an agreement, the bargaining must reach a stalemate at least twice. So what that means is either the union bargaining party or the employer bargaining party will reject the offer from the other side at least twice. Then the authority will step in and they will set minimum terms and conditions. And I think we can see some of the issues there already, which we'll talk about later on, but the authority is not involved in that industry. How is it that they can then set the terms and conditions based on just the paperwork in front of them? So no favourable vote means that the outcome is out of the party's hands, very much like taking a case to the authority. You put your best foot forward and you wait for a third party to make a decision for you. So that could be very complex and undesirable. So let's look at the contents of the FPAs now. And there's two aspects to this. These are the minimum inclusions, and there was a lot of debate about this and went through select committee. The first is obvious. You must have a commencement date and an expiry date for the FPA, very much like a collective agreement, whereas an individual employment agreement only needs a commencement date unless it's fixed term. Secondly, you look at the coverage of the FPA. Now, I think this will be a hotly debated topic in terms of, well, who does it actually cover? There will be a debate from the union bargaining party and the employer bargaining party. The union party trying to extend the coverage and the employer party perhaps trying to reduce the coverage. So we'll see how that plays out, but very much like a CA, coverage will become crucial. You then look at standard hours of work, and that could be on a daily basis, on a weekly basis, a fortnightly basis. Is the standard working week at the moment 37.5 hours or 40 hours? Is the standard working day 7.5 or 8 days? And with the introduction of 4-day working weeks, there's a complexity there of some industries might say, well, we think it's more productive to have 4-day working weeks. So there'll be a whole lot of debate, I suspect, about what is standard in the industry. Then you look at the wages. So what is the minimum base wage rate? So we have the minimum wages. So from the 1st of April, we'll have the minimum wage in New Zealand. This minimum base wage rate is going to be above that. Unions will argue for at least the living wage, which is a couple of dollars more than the minimum wage. And what we'll find is that industries from around New Zealand will all be taken to a minimum base rate. Now, there is a district distinction, which I'll come to soon. But in reality, if you are an industry in Auckland and your base rate is X, and there's another industry in, say, Invercargill, and their base rate is Y, they'll take it to the highest of those base rates. And so that's minimum for everybody around New Zealand in that industry or sector. They'll then look at overtime and penalty rates. So some people don't provide for overtime rates above the minimum base rate. Some provide for 1.25, some 1.5. And going back, certainly in our past, I've seen 2 and 3 times for overtime rates. And also penal rates or penalty rates. So that will also be provided for in there. And then the ability to adjust rates. So we'll see wages as very contestable. If you are a small business and you don't have insight or involvement in the bargaining, you've got to rely on your association. And I would suggest you certainly make it clear to them, where you sit on wages and reasons why. Then we'll look at training and development. So there'll be minimum entitlements for training and development. And that I see is perhaps one of the best parts of this process, because training and development in a employment context is crucial. They'll then look at leave entitlements. Now, at the moment, we have our minimum standard leave entitlements under the Holidays Act. Some companies, for example, might provide 20 days sick leave per annum, or 5 weeks annual leave, or extended bereavement leave. And if that is the minimum, again, all businesses will be brought up to that minimum. And look at governance arrangements within the organisation. Not suggesting they go and look at directors and boards and how they do things, but the governance of the employment side, and then just simply the process for bargaining. When you get together, there is an inter-party bargaining agreement that must be entered into and agreed between both the employer, bargaining parties between themselves, and then over here with the union. And then there'll be a bargaining agreement between the employers and the union. So you'll have agreement within each party and then one between each party. But here are some of the minimum discussions. The first one is the objectives of the FPA. And that in itself perhaps is less important than some of the more pointy end of the terms, but it does set a flavour and a theme, I think, for the FPA, and so some people might feel that that's important. Health and safety, I would have thought that should have been mandatory rather than a minimum discussion point, but I see that each business is different, and as Stephen said in his opening, each business is different and must look at this in the way that relates to their industry and their own individual business. So health and safety will become a discussion. Again, I think that's one of the good parts about this. Flexible working, noting that under Part 6AA at the moment of the Employment Relations Act, you have flexible working statutory requirements, and under the Holidays Act, certainly for domestic violence, there's flexible working requirements. So you've got those statutory minimums. Maybe they're looking at increasing beyond that, because of course an employer under both the Holidays Act and the Employment Relations Act have an ability with good reason to decline flexible working. And then redundancy. As we heard recently, the current Prime Minister has taken the income protection scheme off the table, which was, of course, going to provide for redundancy protection for all employees. So I suspect redundancy will now become more important under this fair pay agreement. New Zealand and Australia, two of the few countries, certainly in the Western world, that doesn't have statutory redundancy. So I see that as being an important issue for discussion. I talked before about the district distinctions and what they call district or regional distinctions. So what it means is that a fair pay agreement can include terms that apply to employees in the district that are different from terms that apply to employee in another district. And it can relate to the minimum base wage rates. It might be that base wage rates in, say, Auckland, Wellington, Christchurch, Queenstown will be higher than perhaps some other centres around New Zealand. The process for adjustment can be distinguished, as can the standard hours. In Auckland, traffic could be a defining factor in terms of starting early, whereas in other centres it may not be. Overtime and penal rates can be distinguished, as can leave. And then redundancy, obviously, which is not a mandatory, but certainly you can have different redundancy discussions for districts. Training and development. Not sure why training development should be regional. I would have thought that should have been consistent, as with health and safety. But those two can be distinguished. And then you've got flexible working. And flexible working, again, subject to the Act, can be distinguished between regions. So if you are in a region in New Zealand where you don't perhaps have the pay rates or the ability to pay redundancy or deal with flexible working like a bigger region, you will be able to have a distinction considered. The idea, I think, would be to make submissions to your employer association so that they ensure that your views on that are heard. Just some other matters before we move on. First of all, representation of Māori. You must use your best endeavours to ensure that those cultural aspects are considered. And in terms of good faith, to be positive and productive in the relationship with the union and to communicate and respond are crucial. The good thing about this new Act is even if there is a difficulty in getting agreement, employees cannot strike. They must carry on. So unlike a CEA where you can strike during bargaining, you certainly can't under this Act here. Right, so how will these FPAs work with other agreements? So let's say a fair pay agreement is finalised. The terms will then automatically apply to the covered employees that meet the threshold test. So whether the employee is a union member or not, whether they're involved in the bargaining through the union or not, is irrelevant. They will be covered by this. And so as a matter of secondary legislation, as an employer, you must automatically agree with and provide the minimum terms in the fair pay agreement to employees that are covered. And that's why I think it's crucial to ensure that your employer association has the right coverage clause. And for most, a more narrow coverage clause would be better, but that will be up for debate. So if a term in an IEA or even a CEA is better than the FPA, then that term will apply. So if perchance the minimum entitlements under the FPAs are not as good as some of your IEAs or your CEA terms, then you apply those other terms. So really, you're getting the best of both worlds. What the FPA does is sets a floor on pay and conditions. So it's raising New Zealand's minimum entitlements as specified for employees. So it complements, in many respects, the minimum wages proposal every, 1st of April every year. and it complements the minimum standards in the Holidays Act and the Employment Relations Act. So the IEAs and the CAs will continue to apply alongside the FPAs. And if a worker's work is covered by more than one FPA, then the more generous FPA will apply. So if you've got an FPA and there's another FPA which has better terms, you apply the better terms. If you have an IEA or a CA that has better terms, you apply the better terms. So it is the floor on paying conditions. So government organisations, how are they actually going to be able to handle this? As you saw before through the MBIE dashboard, there is a high degree of input from MBIE and also from the Employment Relations Authority. So MBIE will need to be involved for most steps of the way once an application is lodged through to actually putting the fair pay agreement agreed by the parties into secondary legislation. So I can see there a significant amount of input. The CEO or his or her delegate will be the person that does that. And again, they'll be learning this process as most of us will as it goes through. The Employment Relations Authority will also have that role, either the default bargaining party or if there's a failure twice to get agreement, setting terms and conditions. So that's going to become quite complex and a little bit artificial. The authority will have an element of information in front of them. Now, it has to be a 3-person authority, not just a 1-person authority, but they don't know the industry as well as you do. They can only work on the information in front of them, and they have to make a decision on whether the union submissions are correct, whether the employer party submissions are correct, or there's a bit of both. So it will be taken out of your hands, and it will be by a third party that has limited knowledge and also limited experience in this area. MBIE will need to check all the applications within the rules and validate the representatives. Now that's, again, just a process-driven matter where, because it's new, everybody has to comply with the rules. And we know that will be complex. If the negotiations are successful, then MBIE still needs to approve the FPA and bring it into force through the secondary legislation. So again, another delay at the end of this. And the parties may agree on something, but MBIE may say, no, we can't agree on that for whatever reason. So we talked about the additional funding for MBIE, but we suspect there will be bottlenecks just simply because this is new, it will take time. And even though there might only be 3 to 5 of these a year, they will be quite complex and will be time consuming. And then there's a question over whether the authority has capacity to assist. If anybody has an authority case recently or at the moment, you'll know there are significant delays in that jurisdiction to now have a large number of authority members involved, even with the use of Zoom or Teams, does add, I think, some complexity and will be difficult. So let's look at some of the positives and the challenges. So some of the positives, it will raise minimum entitlements. So at the moment, the minimum wage compared to the living wage is roughly $2 odd difference, noting that the living wage was set perhaps prior to some of the excessive inflation. So I think next year's living wage will be quite a bit higher. The idea here, I think, from unions will be to raise the minimum beyond the minimum wage into the living wage and beyond that. That will be complex for some employers, and it's complex for a couple of reasons. First of all, those who are paid the least in the organisation are going to get a relatively big bump if there's a fair pay agreement which is entered into and you don't have a regional distinction. And that bump could be, at least in my view, $2 per hour. So that's a cost to you as a business. On top of that, though, people who are above those close to minimum wage will also demand more. So there's this cascading effect that goes up the chain, where if you're moving somebody from over $2 from the lower level around the minimum wage up to above that, then people above that need to be increased. So productivity may be achieved by employers saying, well, we're paying people more, we will employ less people and we expect more of people. It may encourage employers to start utilising technology Chat GPT, for example, and its iterations as we proceed might become more important. Automation in factories may become more important because the cost of labour is just simply too high. So that could result in higher unemployment rates in New Zealand, but at the same time, we may raise productivity. And that's one of the prime focuses here of this process. Are we going to raise productivity by raising the minimum entitlements? If we do it by paying less people more and expecting more of them, perhaps we will, but at the cost of unemployment. And of course, at the moment in New Zealand, our unemployment rate is historically low, so it might be that that will free up some people in the labour market to assist in other areas. The involvement of SMEs is important here, and it is a positive because what we see is that SMEs aren't typically involved in collective bargaining, and certainly outside Auckland, Wellington, Christchurch, collective bargaining, other than perhaps ports, mines, and some other areas, is less common. So it may be that SMEs will become more involved, or, and this is a problem we'll see otherwise, they may not know what's going on. They may become less involved. The next positive is that it will provide a more even playing field for employers in an industry. So if all employers are paying a base minimum and providing minimum entitlements, that provides an even playing field so that one employer doesn't have a natural advantage over another employer just because they're paying people less. So it's an issue, and I know there are issues, for example, where some employers have tax exemptions, for example, by being a charity. Other employers that don't have such tax exemptions might say, well, it's not an even playing field because that employer doesn't have the same cost structure that we do. So that might be a positive consequence here. And lastly, it will promote discussions between employers and unions. And it depends what industry you're in, but many industries have fraught relationships between employers and unions only representing, say, 16, 17% of the workforce. But in some industries, it's a very high percentage they represent. And it's always good to have a positive relationship between an employer and a union so you can get things done. So it'll be interesting to see if some of those positives come through. But there will be challenges. In terms of the coverage of the FPAs, defining that coverage clause, I think, will be complex. A number of employees may have a title but do something slightly different and might feel they don't come within that coverage. We're going to rely on the Australian New Zealand standards in terms of classifications, but I think it will be complex and it will have an impact on market forces. At the moment, good employers with good terms and conditions are able to both recruit and retain employees. If we start seeing an evening out, employees may be less likely to move from one industry or even one employer within industry to another because there's much of a muchness. Secondly, the backstop position of the authority where there's no employer associations. We've already talked about this, but for me, that will be complex for the authority, and I think it could lead to some undesirable results, certainly for some employers, insofar as the authority has limited resources and limited knowledge, typically, of certain industries. Thirdly, the notification requirements for unions. So union membership becomes irrelevant. The employer will have obligations to notify its employees. Employees have a right to opt out of this notification, but you can't opt out of the results of the FPA. And if you think that 60% are union members, so 84% are not, a large portion of the workforce are going to get involved with unions when they haven't freely chosen to do so, whether the union's doing something for them on the side indirectly or whether it's direct, and whether it gives them an advantage or not. And if I'm a union member and I'm paying, say, $15 a week for the union membership, excuse me, and other people are getting the same benefits that I'm getting, I might feel a little bit aggrieved by that. So I can see some complexity there for unions. I think for SMEs, they will be covered typically without representation. And what we mean by that is you may have an employer association belong to, you may not, but if you're in that industry, and you're brought in, you may not have, first of all, the knowledge that this is going on, and secondly, input into the strategy for the employer bargaining side, and then input into the bargaining itself. So if you are an SME and there are, you do have an employer association and they are subject to an FPA, I would suggest making yourself known and providing any submissions that you think are relevant. And so what happens to employers who do not participate in this? So if you're an employer who either through default or lack of knowledge or lack of your communication are not participating in this, you might suddenly get communication to say, by the way, you must now pay your employees $2 extra per hour, plus give them redundancy, plus do this, that, and the next thing. And you would rightfully say, but I'm running my own business. The FPA, the unions, and the government are stepping into the shoes of the employer. And that will be complex, and that will cause, I think, some liquidity issues for some employers who say, well, I just simply can't afford that. And in the context of everything going on in New Zealand and worldwide at the moment, is this the right time to have these minimum entitlements enforced upon you? So you can see here there are a large number of challenges, and there will be more, as there will be more positives, and it's just a balancing exercise. So what are we yet to know? And there's a lot. As with any new legislation, there's a lot to know. So I'll just go previous slide. There we go. There's significant uncertainty remains about how all this is going to work in practice. And like any new bit of legislation, it really comes back to litigation forming the case law. So what we will see is, I suspect, some bargaining over this first set of FPAs. There will be some uncertainty, which the bus and coach industry or the supermarket industry or hospitality industry will say, well, we don't like that. We will take it to the authority separate to fair pay agreements just to dispute elements of this. Now, it'll be interesting to see if they can, and if indeed if they do. But I suspect the authority will play a big part in assisting us in interpreting this process as we go through. Secondly, for a lot of employer groups, there's really not the current coordination or experience or resource to be able to participate in this sort of process. This is nationwide. It's multi-employer bargaining with unions at a very grand scale. So for many employers and the employer groups that are involved, it will be difficult. If you are an employer and you feel strongly about this, you'll probably want to look at the constitution of your employer association and see that you can get involved in this in some way. Is it possible that you can attend the bargaining, at least as an observer? Can you attend national meetings, either by Zoom or Teams or in person with your employer group and have, your say, so at least you've been heard. Lastly, the outcomes for the bargaining process really going to be largely driven by unions, with the possibility of unsustainable outcomes for employers. So we query if the unions have the ability to enter into and participate fully in these processes. We're involved in a lot of bargaining processes with collectives at the moment, and we see the unions often are just running from one collective to another. They simply don't have the resources to get involved. This will be a very large, complex process that they'll need to be involved with, and for them, $50,000 will go some way towards assisting, but it will take a bit more than that. So again, many questions will remain. One of the biggest questions for me is, if there is a national or a right-led government post the election in October, will the fair pay agreement legislation be scrapped? What we hear at the moment is it will. Then the next question is, well, if we've entered into bargaining this year and haven't or agreed on a fair pay agreement, what does that mean? And in part, I think it means that the unions gain some traction within an industry about where they think things should go. If the FPA is not agreed to next collective bargaining round, they'll be really pushing those issues that they did in FPA to say, this is what we want. So it may lead even if this legislation is, redacted after October, it may lead to more complex bargaining for collectives in the future. It may also lead to more individuals saying, actually, I want to be involved with the union. I see I can get some benefit from this. So you can see there's a huge number of unknowns at the moment. And as we say, many questions will remain. The legislation itself is quite complex and long. We can go into elements of it, but we haven't got time today. But in essence, it is a wait and see. So that is the presentation so far. So Stephen, I'm happy to answer any questions. This is our waiver, along with our team, nationwide team, Elaine Neve. If you do have any questions that are bespoke to your business, by all means, contact us or your own lawyers and hear from them. Thanks, Stephen.
Thank you, Andrew. Insightful, a little bit scary, and a little bit of the unknown, and a little bit maybe not at all. So I think it's very much a wait and see. But I know for those that are on the call, and we will have this recorded version of this available on our website. So if anyone does have any questions, please do put them through. One question that's come through: this is going to be an expensive practice for employers.
The answer to that is yes and no. If you're an employer, you might take a view that I don't think this is going to come into play. I don't think we're going to get agreement. I don't think it's going to impact on me because I pay my staff pretty well. I'm going to do nothing. But I suggest you'll have a lot of employers who will say, if this comes into place, it's going to really impact on my business, so I need to be involved. So yes, it will cost them. And our firm is involved in a couple of these already in terms of potentials and current. And we do know that there are some concerned employers, and it will cost another cost of business.
So what about those employers that have a mixed workforce in terms of employees and contractors? So how will it impact those that are contracting to a business?
So two things about that. The government's recognised that some employers might try and get around the FPA by bringing more contractors into their business. You can certainly bring contracts into your business, but you've got to be very careful that they're not deemed to be employees. So it's both a tax and an employment test as to whether someone's truly running their own business as a contractor. They're under your control as an employee. So that's the first thing. Don't think you can get around this by bringing in contracts unless genuinely that's something that you want to do for your business. But it will impact on contractors, because if employees' wages go up, contractors might say, well, actually, my rates are going to go up to match what the employees are getting if you want me as a contractor. So I can see, again, a cascading effect, not just through employees, but also out through contractors.
Okay, yep. I've put in the chat for everybody the MB dashboard, and I suppose there is a growing sort of wealth of information available as there is more publication about fair pay agreements. But would you accept that the MB website is probably the source of the truth for further information for people?
Yeah, it's not as updated as it perhaps should be at the moment. But yes, I think because MB is so heavily involved in the FPAs, I would go there first to see what is actually happening. And if you look at their website, it's relatively concise, and it provides really good resources to review. I mean, the legislation itself is much longer and more complex, so that will require legal advice. So if it really is of concern to you, seek legal advice, but otherwise MB's fine. And there's other various websites you can go to from the government which will help as well.
And so just to finish up, and I think you made a great point around legal advice. So for any employer, if they're faced with a fair pay agreement action that they're going to be part of, would it be prudent to just have that upfront initial chat with their legal representation, just so the coast may be a little bit clearer?
Yeah, I think it is. I mean, it's like anything, you've got to spend a bit of money to ensure that you've got the right position going forward. If the implications of a fair pay agreement could be significant to your business, see your lawyer. If you're not too concerned, review MB website and keep involved.
Okay. All right. Well, we've covered a lot of territory, so we'll wrap things up there. And it just leaves me to say thank you to you. An excellent presentation, lots of information, and I'm sure that everyone online has taken something away from this. And so, Andrew, thank you, and we very much appreciate your time. And to everyone that's joined us, thank you. And to everyone that's joined us today, thank you for your time this morning, wherever you are in the country.